Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Imagine this. A really high-stakes legal fight stretching across continents. You've got a Canadian company, a big South Korean tech player, and this really crucial Indian patent right in the middle.
Yeah, and the real question isn't just, who's right or wrong legally.
Exactly. It's how do you actually get justice? How do you enforce a win when the other side's money, their assets, are like halfway around the globe?
Right. It's about making judgments stick.
Precisely. This isn't just some dry legal document we're talking about today. It's a proper deep dive into how courts, specifically Indian courts, are making sure their decisions actually matter. So today we're unpacking a landmark judgment from the High Court of Delhi. And it's got really significant implications for how Indian courts deal with intellectual property rights, especially against foreign companies.
Absolutely. Huge implications.
Our mission, really, is to get into the weeds of this case, understand the arguments from both sides, look at the court's pretty powerful decision, and figure out why this sets such an important precedent. Ensuring justice isn't just some idea, but something actually enforced.
Okay, let's get into it.
So the basic details first. The case name is Communication Components Antenna Inc. versus ACE Technologies Corp and others. That's ORs for others.
And the case number for those tracking is CSC C2MM 1222018.
Right. And this judgment came from the High Court of Delhi, New Delhi specifically. It was handed down on July 1st, 2025.
And the judge presiding was the Honorable Mr. Justice Saurabh Banerjee.
Okay, the players. On one side, the plaintiff, Communication Components Antenna Inc. Let's call them CCAI. They're a private Canadian company based out in Ottawa.
And they hold Indian patent number 2480893. This patent is apparently quite important for cellular base station products.
Okay, and facing them, the defendants. Defendant number one, and the main one fighting this, is ACE Technologies Corp, a South Korean company.
Then you've got defendant number 2, Shin-Ah Ltd., based in Hong Kong, and also defendants 3 and 4, who are unnamed Indian subsidiaries.
Got it. And the lawyers. For CCAI, the plaintiff, the team was led by senior advocate Mr. J. Sai Deepak, working with Mr. Mohit Goel, Mr. Siddhant Goel, Mr. Deepankar Mishra, Mr. Aditya Goel, and Mr. Avinash K. Sharma.
And representing the defendants, ACE Technologies and the others, were Mr. Suraj Kumar Singh, Mr. Farat Singh, and Mr. Abhay Singh.
Now, the timeline here is pretty long. CCAI actually started this suit way back in 2018.
Yeah, it's been going for a while.
It really has. Over the years since then, there have been, multiple interim orders, mainly about security deposits. There were appeals up to the division bench of the Delhi High Court, even went to the Supreme Court at one point.
Wow.
Yeah, all leading up to this big judgment we're discussing on July 1st, 2025. So it's been quite a journey through the courts.
Definitely a long road. So let's dig into the heart of it. What's the core dispute here?
It all comes down to that Indian patent, number 2400893, held by CCAI. It relates to cellular base station tech.
Right. And CCAI accused ACE Technologies, the South Korean firm and its subsidiaries, of infringing this patent, basically making and selling similar antennas that use their patented technology.
What's really interesting, though, is how the court handled this early on. Back on July 12, 2019, a single judge at the Delhi High Court made what's called a prima facie finding.
Which is like an initial assessment based on the evidence so far.
Exactly. And that initial assessment was that the defendants were infringing CCAI's patent. But the key thing was, given that ACE Technologies and Shin-Ah were foreign companies, and crucially didn't have many assets in India.
The asset issue again.
Right. The court did something quite proactive. It ordered them to put down security deposits then, a bank guarantee for 40 crore rupees for past sales, and another 14.5 crore rupees for sales happening while the lawsuit was ongoing.
Which was about, 10% of their sales at the time?
Roughly, yeah, a significant chunk.
And did that order stick? Because you often see these things challenged.
Oh, it was definitely challenged. But it was firmly upheld. First by the Delhi High Court's division bench. That was August 8th, 2019. They specifically pointed out, look, these main defendants are foreign. They don't have assets here.
Makes sense.
And then even the Supreme Court looked at it, September 20th, 2019. They said there was absolutely no necessity to interfere with the single judge's order, calling it well-reasoned. They even highlighted that the Korean company is not ordinarily subject to our jurisdiction.
So the highest courts basically backed up that early security deposit requirement. That's pretty strong.
It really set a tone. Okay, so let's fast forward. The main lawsuit, the actual infringement case, is still technically ongoing. It's at the evidence recording stage now.
Still chugging along then.
Yeah. But late in 2024, the plaintiff, CCAI, filed a new application. They wanted more security. What prompted that, especially after getting those initial deposits confirmed?
Well, it seems things came to a head with an affidavit filed by the defendants on November 12, 2024. This document laid out exactly what assets they did have in India.
And it wasn't much.
Apparently not. Roughly 5.68 crore rupees in cash. Maybe 4 to 5 crore rupees in machinery and equipment, which, depreciates. And some land they value themselves in about 18 crore rupees.
Okay. But how does that stack up against what CCAI was claiming?
That's the kicker. CCAI's claimed damages were around 1,160 crore rupees. That's roughly, 140 million US dollars?
Wow. Okay, so the assets disclosed in India, barely a drop in the ocean compared to the claim.
Exactly. A massive imbalance. And there was more fueling CCAI's worry.
Oh.
The court also noted that defendant number 1, Ace Technologies, had seen its share value drop significantly over 64.9%. And they'd also admitted they stopped operations in India because they weren't getting orders from a major client, Reliance Jio.
So you've got tiny assets in India, a huge claim, and signs of potential financial wobbles from the main defendant. Okay, I can see why CCAI pushed for more security.
Precisely. It paints a risky picture for the plaintiff if they eventually win that massive claim.
So, given all that, what was CCAI's main legal argument for demanding even more security now?
Their core argument centered on this concept they called the reciprocity challenge. Basically, they pointed out that South Korea, where Ace Technologies is based, is not what's called a reciprocating territory under Section 44A of India's Civil Procedure Code, the CPC.
Okay, what does that mean in practice? Reciprocity.
It means there's no formal treaty or arrangement between India and South Korea for automatically recognizing and enforcing each other's court judgments. So even if CCAI won a massive judgment for 1,160 crore rupees in the Delhi High Court,
it wouldn't automatically be enforceable in South Korea.
Exactly. It would be, as the court later put it, liable for scrutiny once again in a South Korean court. It essentially would have no sanctity there automatically. You'd have to effectively relitigate aspects of it.
That sounds like a huge hurdle. Almost makes the Indian judgment pointless if the assets are all in Korea.
That was precisely CCAI's fear. And it wasn't just theoretical. They actually cited a previous painful experience.
They'd been through this before.
Apparently, yes. They mentioned a case where they got a damages decree for 217 crore rupees against a company based in China, another non-reciprocating territory. But that decree ended up being infructuous.
Meaning useless. They couldn't collect.
Exactly. They had no way to recover the money. So you can imagine, having gone through that once, they were desperate to avoid a repeat with Ace Technologies. It showed the very real risk they were facing.
Wow. Okay, so that past experience really highlights the problem. And combined with the defendant's tiny assets in India.
Right. Those Indian assets, as we said, were clearly nowhere near enough to cover the 1,160 crore claim. Relying on those alone would be futile.
So if the usual rules for enforcing judgments across borders didn't apply easily, how did CCAI argue the court could help them secure their potential win?
They turned to Section 151 of the Civil Procedure Code. This is a really important provision that gives courts inherent powers.
Inherent powers, like powers not explicitly written down for every single situation.
Exactly. It allows courts to make orders necessary to achieve the ends of justice or prevent abuse of process, especially when there isn't another specific rule that fits the situation perfectly.
Okay.
CCAI argued that the usual rule for securing assets before judgment, which is Order XX8 Rule 5, didn't really apply here.
Yeah.
That rule is more about attaching specific property within India when you fear the defendant might get rid of it.
But here the issue wasn't disposal, it was just the assets weren't in India in the first place, mostly.
Precisely. There wasn't enough substantial property in India to attach. So CCAI argued, Section 151, the inherent power, was the only way the court could step in and ensure justice wasn't thwarted, to prevent them from being, quote, remediless.
And they had that earlier prima facie finding of infringement to lean on, right? The one upheld by the higher courts.
Absolutely. They highlighted that point strongly. It showed their claim wasn't frivolous. There was already a judicial finding, albeit preliminary, that infringement was likely happening. That gave their request for security serious weight.
Okay, makes sense. And then the final piece was the financial picture you mentioned.
Yes, that significant drop in Ace Technologies' share price and the fact they'd stopped their Indian operations. CCAI argued this created a very real worry that by the time the full trial finished, Ace might not even be able to pay a large judgment. All these factors together formed their case for needing substantial additional security now.
A compelling argument, certainly. But Ace Technologies must have pushed back hard. What were their counter-arguments against putting down even more money?
Oh, definitely. Their main response to the reciprocity problem was to say, hey, wait a minute. Even if India doesn't have a Section 44A arrangement with South Korea, our own domestic law in South Korea does recognize and enforce foreign judgments.
So they were saying, don't worry, our courts will enforce your judgment anyway.
Essentially, yes. They pointed to Article 217 of the Korean Civil Procedure Act. They argued that because Korean law allows for enforcement of foreign judgments, under certain conditions, presumably, the lack of a formal Indian notification under Section 44A shouldn't be grounds for the Indian court to take such a drastic step, like demanding huge security up front. Okay, that's a direct counter on the enforceability point. What else?
They also tried to distance themselves from a key case CCAI relied on, the Nokia Technologies case. Ace argued that case was different because it involved standard essential patents and a company that was already a licensee. They said that's not us, so that precedent doesn't really apply here.
And what about the infringement finding itself? Did they challenge that?
They did. They stressed that the prima facie finding was just that preliminary. It was made before all the technical evidence, like detailed claim mapping, had been presented and examined.
So they were saying infringement hadn't been conclusively proven yet. Exactly. They argued that the appeal courts themselves had noted the need for expert evidence down the line to make a final call. So they were basically saying, hold on, the infringement isn't a done deal. You can't base such a massive security order on just a preliminary finding.
Okay. And they must have pointed to the money they'd already deposited, right? The 70 crores?
Absolutely. They used that figure, about 70 crores in total, already deposited as proof of their bona fides, their good faith. They argued this showed they weren't about to disappear or flee the jurisdiction, so there was no real risk justifying more security.
Did they address CCAI's bad experience with the Chinese company?
Yes. They tried to distinguish that Moby antenna case, too. They claimed the defendant in that case had basically given up and abandoned the proceedings, whereas they, Ace Technologies, were actively participating in defending the suit. Different situation, they argued.
They also raised a broader legal point about interim relief, didn't they?
They did. They argued that ordering them to deposit such a huge sum before the final judgment was essentially granting the plaintiff the final relief, or a large part of it, at an interim stage.
And that's generally not done.
Well, they argued it should only happen in rare and exceptional cases, citing a Supreme Court case, Dheeraj versus State of Maharashtra. They claimed this case didn't meet that high standard, wasn't exceptional enough to warrant such an order, unless failing to do so would really prick the conscience of the court.
Okay. And finally, what about their financial health? Did they counter CCAI's concerns?
Yes. Despite the share price drop and stopping Indian operations, the CFO of Ace Technologies filed an affidavit. In it, they asserted that the company was still in a healthy financial position and fully capable of satisfying any potential decree if they lost.
And the reason for stopping Indian operations?
They attributed it to the lack of orders from Reliance Jio, framing it more as a specific business issue rather than a sign of overall financial collapse.
So two very different narratives presented to Justice Banerjee. One of imminent risk and potential futility, the other of good faith, ongoing legal process, and financial stability.
A classic courtroom class.
All right, the moment we've been building up to, the decision. What did Justice Saurabh Banerjee decide on July 1st, 2025?
He allowed the plaintiff's application. He sided with CCAI.
Wow. So what did he order Ace Technologies to do?
He directed defendant number 1, Ace Technology Corporation, to furnish and deposit an additional amount. And it was substantial. It was equivalent to 25% of the total claim damages.
25% of 1,160 crore rupees.
That comes out to 290 crore rupees, a huge sum.
So another 290 crores on top of the 70 crores already there.
Exactly. This additional 290 crores had to be deposited, either as a bank guarantee or a fixed deposit receipt, with the court's registrar general within 4 weeks.
That is a massive interim order. What was the judge's core reasoning for demanding such a large amount before the final judgment?
Well, the judgment tackled the key issues head-on. First, that crucial reciprocity challenge. The court made a definitive finding. South Korea does not have a reciprocal arrangement with India for enforcing decrees automatically under Section 44A.
So the court agreed with CCAI on that core point.
Yes. The judge stated clearly that an Indian decree against ACE Technologies would not be automatically enforceable and would essentially have no sanctity in South Korea without going through their local process. This directly validated CCAI's biggest fear.
Okay, so the risk of an infructuous decree was real in the court's eyes. What about the defendant's assets in India?
The court explicitly acknowledged them. Justice Banerjee noted the defendants' disclosed assets in India were limited and grossly insufficient to satisfy a potential decree of the magnitude claimed, the 1160 crores. This left CCAI dangerously exposed if they won.
Which brings us back to Section 151, the inherent powers. How did the court view using that?
The court found it was not only appropriate, but necessary. Justice Banerjee affirmed that Section 151 CPC was the right tool here, because otherwise, the plaintiff, CCAI, was essentially remediless.
So the court felt it had to use its inherent power.
Yes, underlining that these powers exist precisely to meet the ends of justice and prevent unfairness when the standard rules don't quite cover the situation. The court even acknowledged the diarrhage principle that interim relief resembling final relief is rare, but felt this was one of those rare and exceptional cases where the court's conscience was indeed pricked, justifying the use of Section 151.
What about the defendant's point that infringement wasn't conclusively proven yet? Did the court address that?
It did. The court essentially said, look, the prima facie finding of infringement from back in 2019 was challenged. It went up to the division bench. It was upheld. For the specific purpose of this application deciding on interim security, that finding had attained finality.
So while the main trial still needs the final proof, that initial finding was strong enough grounds for ordering security now.
That was the court's position. The detailed evidence would come later in the main suit, but the upheld prima facie finding was enough justification for this interim measure.
Okay, and how did the court weigh the balance of convenience and the risk of harm?
The court found a strong prima facie case overall for the plaintiff, CCAI. And crucially, it found the balance of convenience was heavily tilting in CCAI's favor.
Meaning the harm to CCI if security wasn't ordered outweighed the harm to ACE if it was.
Exactly. The court concluded that without these safeguards, irreparable harm, loss, and injury would likely occur to the plaintiff. It might even render the whole lawsuit odious pointless, especially given ACE's declining share value and the fact they'd stopped operating in India. The risk of them not being able to pay later was too high.
Did the court mention the defendants not paying earlier deposits?
Yes. The court also noted the defendant's lack of deposits in the preceding year, seeing it as reflecting a precarious state, and continued non-compliance, which further supported the need for a strong order now.
It really sounds like the court was determined to prevent CCAI from winning a hollow victory. Did the judge rely heavily on legal precedents to justify such a strong move?
Absolutely. The judgment is packed with references. As we mentioned, Diarrhage versus State of Maharashtra was key for justifying the potentially final nature of the interim relief in exceptional cases.
Right.
Then there was Rahul S. Shah versus Janendra Kumar Gandhi, which affirmed the court's power under Section 151 to demand security specifically in money suits.
Okay.
M. Ramachandra Rao versus Varaprasad Rao was cited to support using Section 151 precisely when the usual attachment rule, Order X68 Rule 5, doesn't fit because there isn't enough attachable property.
In the Nokia case, the defendants tried to dismiss.
Still relevant. The court used Nokia Technologies versus Guangdong Automobile to reinforce the use of inherent power under Section 151, specifically for balancing equities by ordering security deposits.
Any other really direct precedents?
Yes. Significantly, the judge cited one of his own previous decisions. Oryx Prism Health Systems versus Canva. That also involved a foreign company with no assets in India, and security was ordered.
Ah, so he dealt with a similar scenario before.
Seems so. And finally, the court explicitly mentioned CCAI's own prior negative experience in the Mobi Antenna Technologies case, where their decree against the Chinese entity became useless. That real-world example clearly demonstrated the necessity for this kind of proactive security measure.
It sounds like a very thorough and well-supported decision, even if quite aggressive in the amount ordered. So stepping back, what's the bigger picture here? What's the precedential value of this ruling? Why does it matter beyond just CCAI and ACE?
Well, it's pretty significant. This decision really expands, or at least very proactively applies, the court's inherent powers under Section 151 CPC. It shows a willingness to compel substantial prejudgment security deposits from foreign defendants, particularly those without significant Indian assets.
It strengthens the court's reach, essentially.
You could say that. It definitely strengthens the court's ability to make its future judgments effective, not just symbolic.
So it acts as a crucial safeguard against those infructuous decrees like the one CCAI suffered before.
Exactly. It provides a powerful mechanism to prevent judgments from becoming meaningless, especially when you're dealing with companies based in non-reciprocating territories like South Korea here, where enforcing an Indian decree is already challenging.
And the sheer amount, 25% of the claim, that must set a benchmark too.
It certainly does. Ordering 49D Crores as interim security is a very strong signal. It establishes a precedent that courts can order very significant amounts when there's a strong initial case, when the balance of convenience clearly favors the plaintiff, and when the risk of irreparable harm is high.
And it highlights specific factors courts will look at now.
Yes. The judgment makes it clear that the foreign defendant's financial stability, or lack thereof, the extent of their assets in India, and whether they cease local operations. These are all key factors that will influence whether such large interim security orders are made.
So ultimately, this feels like a big win for intellectual property holders fighting infringement in India, especially against overseas companies.
No question, it serves as a really vital safeguard. For patent holders like CCAI and potentially other plaintiffs in high-value disputes, it offers a way to ensure that if they go through the long process of proving their case, there might actually be something tangible at the end of it. It makes justice more actionable in these complex cross-border IP fights.
So the key takeaway, it seems, is this clear signal from the Delhi High Court. Indian courts are getting serious about enforcement. They're willing to use their inherent powers proactively to make sure plaintiffs aren't left empty-handed, especially when dealing with foreign entities with limited local ties.
Right. It's a move beyond just declaring rights to actively securing the potential remedy, demanding significant assets up front to guarantee the judgment won't be futile. It really changes the dynamic in these cross-border IP cases.
And this isn't just some niche patent law thing, is it?
Not at all. It speaks to a much bigger issue in our globalized world. How do legal systems cope when value and assets are increasingly intangible or located elsewhere? This decision is a strong statement that geographical borders shouldn't automatically shield companies from accountability.
It's about making the legal system effective in a modern context.
Precisely. Balancing the scales for those whose rights have been infringed, ensuring the whole process leads to a meaningful outcome, making the promise of justice real.
Okay, so here's a final thought for you, our listeners, to chew on. Given this ruling, this proactive securing of assets, what might it mean for foreign companies? How might they change the way they structure their operations or where they hold assets when doing business in India?
That's a great question, especially in sectors heavy on intellectual property.
Could it encourage investment by showing India protects IP holders strongly? Or might it discourage some if they fear being forced to park large sums here pre-judgment? It definitely adds a fascinating new wrinkle to thinking about foreign direct investment and global business strategy in India.